Freeman bites me.
You can play
I don't know, sometimes they're pretty good bites.
Call this meeting to order of the Court Services Advisory Board. Notice of this meeting was properly posted on July 24, 2024. We'll do roll call.
Brian Bond.
Rick Warren.
Joe Stoner.
Jim Anderson for Sheriff Tommy Johnson.
Butch Freeman.
Vicky Behemoth.
Bridget Biffle. Let's see, discussion and possible action regarding the minutes of May 9th, 2024.
So moved.
Second.
All in favor?
Aye.
All opposed? Okay, and then the first item under departmental items, discussion and possible action regarding the transfer of the operation and management of the duties provided by Court Services Office from county to team. I know Jamie Patterson is here to talk about just the numbers that they have or who it was transferred.
So in terms of the number that were transferred from the county over to us, we had 237 on OR bonds, 37 on conditional bonds, and then also 10 of the treatment court ankle monitors. Yeah, things are great.
How's it going?
It's going well. There's definitely some kind of procedural growing pains, but the collaboration and communication with everyone has been really great. Kind of figuring out how we make sure that background checks are getting to the right people and that the bond requests are coming from attorneys and all of those different things are getting worked out really well. So.
I heard there was a little bit of an ankle monitor shortage at one point.
Yes, we borrowed one and we have it, so no one went without an ankle monitor, and we now have our inventory is up.
Where do you get those from?
Allied Universal.
They don't come from the county?
No, it's a different Allied Universal. It's the same company that the county uses. The Department of Corrections also uses it for their ankle monitoring as well. So they got shipped in, I believe, from Texas. And they overnight them. They're pretty fast.
They come here. Does team pay for those, or those for the county, or how's it work?
Team is paying for them right now.
Did you bill us?
There was a line item in the budget for the county for those, unless the judge orders that the individual has to pay for them.
And so, well, usually what I do, I usually put in an ankle monitor, but then I would put on there or to be paid with indigent funds. So it's usually reversed. So the assumption is they're going to pay unless it says specifically that they're going to pay with indigent funds.
I see.
That's what I've been doing, and we could do it the other way if you want specific, but then to pay.
I think that's up to
the
court, but we don't want that to be a barrier to. And then what we're hearing from other agencies that do require payment for the ankle monitoring services is that people just get behind and paying this. But you have to keep the ankle monitor on. Of course, we're not going to cut someone's ankle monitor off because they didn't pay, right? So
we
it just
still
makes,
monitor.
correct, absolutely, regardless of their payment. We have never charged for ankle monitors before and would prefer not to, but that's obviously up to.
We can talk more about
Sure.
the details on that.
Yes, and that the indigent fund is still a fund with the county, so the I think the treatment court ankle monitors have court orders saying to be paid by indigent funds.
Most of them do. Every once in a while, I'll have somebody who has the ability to pay, and I would just not put that on there. But yeah, okay. Is Sean part going okay?
It is, yes. We are trying to hire some more crew chiefs. We do have 2 right now, and we would like to have 4. So if anyone who would like to be a crew chief, let us know. We do have a few good applicants in right now. We're just scheduling interviews for. But yeah, we're definitely trying to let them too.
Is it growing?
I don't know that we've had it long enough to know if it's growing yet.
That's your plan?
That's the plan.
Great
Yes,
program.
that's the plan.
I know a guy that's worked on it a lot of years.
Oh, really? You want to come back?
About me. Not in bed, right?
Oh, that's right. Yes, yes.
I can piggyback on that though to say there was a little back and forth between the DA and the municipal counselor over a clause in the city contracts which largely underfunded or underwrite it, and we adopted, the DA's position was it was really a policy decision, and so we went ahead and adopted it as is with the agreement that we could come back and work it out. However, it contained red lines in the adopted version, and the city won't accept it. And so that's going to create a 3-week delay now for that, even though they were the ones who stuck the red lines in there.
The city did.
And it's over just one little clause. It's because there's now a river trust, and they do like the zoo trust and the river trust, and then there's some of it's Oklahoma City, but it's public works, and it's just their bureaucracy within how they do their pay channels to send the money per whatever task they called on us to do. And the river trust was a new one, but it laces through it, and so. There's lines in there because it continues to relate to that. It was a new thing. This isn't like a fumbled thing from a typical play that we typically do over and over. And you're like, why did you screw up and stub your toe this time? It's just because in the middle of all this other, unrelatedly, there was a new thing introduced into the contract. But we'll get it worked out. There's not a concern that won't be resolved. It's just with the city council only meeting twice a month and then our deadlines. So by the time now we get it back to them, it'll be 3 weeks.
So those are the vendor contracts is what he's referring to, right? The
Yes.
city has,
But
or the
were-
county has contracts with various
Mhm.
vendors.
We have, we contacted the city and said, we understand this is a service that the city needs, so if you would allow us to volunteer to clean up. In the meantime, we're happy to
Oh,
do
wow.
that. They just got that approved this week, so this morning we've been out cleaning up.
Because the constituents are blowing up the phones. It was telltale to be only couched for a couple of weeks for this stuff to explode, and people realize the sheer amount that's being hauled off. But thankfully, they were late paying us, and so that gives us some cush. So for anybody's concerns about if we have operating capital because of a delayed payment from the city, there actually is some money that just got into the treasury. So we can balance it for a little while without having this contract, because I think they will not be able to retro pay us. I think what she said is accurate. It will be volunteer. But it's for public service because the public is sure suffering from these blighted out, ratted out areas that they're accustomed to us tidying up.
And can I just go back on one point? Judge, I would like to talk to you about the GPS indigent fund, because I think the county that has, and Kathy Taylor has a certain group of people that she monitors on GPS. Most of those people are they're not coming from a diversion program, they're coming from the district judges, and they require them to pay. That's what Jamie's talking about. A lot of those people can't pay. But we have to keep GPS on them. So I think there needs to be a discussion, now's not the time to do it, about whether or not the county does provide funding for indigent defendants who can't pay for GPS monitoring. We might think about maybe going there first. I mean, for somebody who truly has the ability to pay, then they pay. But the district judges are mostly ordering those people to pay for the GPS monitoring, and they can't. So we just need to have
They'll pay a
another,
little bit, they quit paying.
and then they can't pay anymore.
It's usually $6 a day. I think they'll.
Well,
It's expensive.
It's very expensive, and I think some of them there are two different types of GPS monitoring. One is the more expensive, that's $12 a day. And that,
Yes. And the unit itself, if it gets lost, is over $1,000.
anyway, so we need to have further discussion.
You're the one, but team is the one that monitors them while they're wearing it, right? In other words, you're doing all the work, are
Many
you or
of
not?
them, there are some
So-
that are going through the district
Not on the
attorney's
one she's
office.
referring to.
Okay, so the ones that the judges require to pay then, are they paying it into our indigent, I can't say the word, but our fund, county money? Are they paying it to the county or not?
Not consistently.
Who are they paying it to?
When
Well,
it
they're
is
not
paid,
paying.
it's paid.
Well, okay, I understand
Oh,
that.
yeah, when they are
When
paid,
they do
it's
pay
paid.
it.
But when they do pay, it
Yeah.
comes to us.
Right.
Do we know
That's
how
how
it's,
it was happening.
do we know how it's being split with which people you're monitoring for GPS and which are being monitored by?
It's an informal agreement right now, but lower level offenders and people that are put on GPS monitoring from the treatment courts are going to team. I call them the higher risk defendants are being monitored by Kathy, who will soon be in the DA's office.
Like effective tomorrow.
I don't know when that transfer is gonna happen. I'm not sure about that. The contract's all been signed, I believe.
And then just so everyone knows, regarding team still supervising everyone, court services has 3 employees that were running the NCICs. The DA's office stopped receiving NCICs, I think as of July 9th. They just 1 or 2 days ago now started receiving summaries. So essentially what effect that had is no one really got out on pretrial release between those times for arraignment and things like that. I think the jail population was down to somewhere around 1,200 months ago, and now I think the jail population today is at 1,527 is the number. So it has completely exploded. We did start getting those backgrounds. We had a meeting on Monday with Commissioner Blumert, and then with some of the people who were helping the employees, Brad and Karen. Alan was there from the district attorney's office, and so we kind of talked about what they needed to see on those NCICs, and so now there's such a backlog that we're trying to work. We've started getting a ton of summaries, but obviously the district attorney's office has to review those, and so now we're just kind of in this period of we're seeing like how fast those can be reviewed and what we can do, because there is a lot of information that has to go through, and so I think that's kind of what's caused. Team's been ready to go, but because they haven't gotten anyone approved without judges and DAs having the NCIC, no one was really approving them, so they haven't really gotten any more people in the last couple of weeks, but hopefully that gets fixed soon.
There's been a few, like, from in the courtroom that judges may be ordering, but it has been very slow.
And we just put an exclamation point on that. It's not team's fault. I mean, it's the remaining court services personnel that was not getting the NCIC reports.
Thank you, Dan.
Thank you.
And do you want to leave this on there for next time to get the update, or what do we want to do with
You're
that?
wanting to make it reoccurring? Is that what you're?
Or should we just take it off right
Well, I
now?
would say,
and have
now we ought to
updates?
tell you some, just an update, kind of a status update from team regarding the, regarding the, their operations.
I do think one thing that might be helpful, I know in particular there was some data that you were looking for, and formerly Mr. Ravitz, and I think if they are willing, from my conversations, they just want to know specifically, they don't want to give you stuff you don't want, have to sift through, but if there are data points that you're wanting them to start tracking, I think now's the time to weigh in on that, or, you know, at least be thinking about it to come back to the next meeting with.
Well, I know, I mean, whenever Grant would give his report, it's maybe something similar to that.
Judge, can I interject? Yeah. So, the court subcommittee in April went through and developed a list of program metrics. They had actually done this previously, and so this is new with some of our new personnel. Previously, court service has resisted following that set of metrics. I have a feeling that Ms. Patterson would be more willing. So if possible, I'd like to, at the next meeting, meet with her, go over those metrics with her and see what their capability is on reporting that, because across the programs, they all agreed that what we were seeking to be requested was not that difficult for them to produce. It's just a matter of how they produce it, how they report it, and then how can, on my end, how do I transfer that to our dashboard so that eventually it'll be out there for you all to not, I mean, obviously this meeting and this report would be a monthly report, but then it would be on our dashboard for that to occur. So if you could just table this or set it aside and let us work for another month to come up with what, but the metrics were already approved by the court subcommittee. So everyone already agrees those are metrics that should be done. And then, or what I can do, Judge, is I'll send you those metrics, and if there's something else you want in there, we can revisit those.
Thank you.
Okay, and so next on the list is discussion and possible action regarding the potential implementation of an evidence-based risk assessment. I know this was on there before. Grant had put it on at some point. I don't know, because we're so early in the transition, I don't know that court services would even be able to do that at this point, but I don't know if we want to ask Jamie or someone to come present on what that assessment looks like in the future. I know there have been some questions about it. I know people have talked about we need some sort of risk assessment. Right now, court services is doing a total workup of any history the individual has. One of them I was looking at went back to the 1980s. So I would probably want more information on what it looks like. I know Judge Stoner previously talked about best practices and kind of what we need to do to look at that. I'm also concerned, I just don't want anything that keeps people from even getting out or potentially kind of stops anyone from getting out. That's my concern, is that people would use the tool to say like, oh, this person can't ever be on probation or anything like that. That's my concern. And I know Mr. Rabbits had kind of tossed that back and forth before, but so I would want to kind of see what information it actually asks for, and maybe someone to present on the PSA or kind of that evidence. So do you have any thoughts?
Right now, what are you using to evaluate someone around whether or not we got those questions that were similar to the ORAS, but were not the ORAS?
So the way the process is working right now is the group at the jail is running the NCIC. They're getting that information to the public defender's office and the district attorney's office. We can't see that information because it's from the law enforcement database. Then the district attorney's office and public defender are telling us who they want us to interview. So, and that's not a risk assessment, it's just here's kind of some basic information that we need to know and then the judge might want to know. So there's not a true evidence-based validated risk assessment being used right now.
You know what NHTSA would recommend?
What NHTSA would recommend?
Yeah, actually, yeah.
Yes, one of their best practice standards is to use an evidence-based validated pretrial risk assessment tool. They do have on their latest version of their best practice standards listed a few, and the PSA is one of them. The other one is the one they use in Virginia, that Virginia actually doesn't use anymore. So everyone's moving to the PSA. The PSA stands for Public Safety Assessment, and it looks at criminal history and age. And based on that, there's some evidence that it can predict risk, not that it will happen, but risk of failure to appear or a new criminal arrest, as well as a new violent criminal arrest kind of underneath that subcategory.
So that we have to do maybe release with certain type of
Correct.
conditions.
Yes. So if you're a level, there's like levels 1, 2, and 3. So if you're a level 1, maybe that's an OR. If it's a level 2, maybe that's a release with these conditions. Maybe level 3s are GPS. That's it is kind of customizable to the jurisdiction, is my understanding. So it would be a conversation maybe of this group and then with the judges and all of that to say, if someone scores this, what is the correct level of supervision for this district or for this jurisdiction?
Is that what you guys are, your team, is that your aspiration to be able to use a tool like that?
We would love to be able to use a tool.
But
Yes.
let's put a fine point on this again. They can't see the criminal history. So that's a problem for them being able to use the PSA. We have talked as early as this morning about whether the court services people actually are trained in how to use that PSA assessment. So it might be worth having this on the agenda for next time for us to discuss it. By that time, hopefully we'll have a better answer on who's going to do it. I think we absolutely need one for sure, as you recognized, Judge, several years ago. But maybe what we ought to do is put that on as an agenda item for next month.
And I'm happy if it's helpful to send some research and evidence on the PSA to Ms. Bickle, and she can send it out to the group if anyone wants to just get familiar with it ahead of time as well.
Okay, and so we'll leave that on as a recurring item and then discuss that at the next meeting. And then the next I have discussion and possible action regarding the mandatory exclusionary crimes list and to consider any amendments to expand eligibility for pretrial release as recommended. I know we've had some conversations about this in the past, and Grant put up the exclusionary list as it exists now. So in the past, court services wouldn't interview anyone based on that list. So they would screen someone's background if it was, say, someone on we'll just say a murder charge. They wouldn't run that person's background. If it was someone on a public drunk, that's not on the exclusionary list, so they would run someone's background and could take it to the judge without the district attorney seeing. Because we've changed the process, now it's being done a little different. Court services isn't taking anything to a judge. So we really need to think about whether we want to, what crimes that we don't want someone to be looked at for pretrial release at all. So it's kind of changed the definition of mandatory exclusionary list. I know the DA's office is now just putting, their DAs who are screening it are putting an objection on anybody who's on that exclusionary list, where in the past the DA's office, if the DA's office or a public defender or attorney or judge wanted that person interviewed, they would just have them interviewed. So them putting an objection on those crimes that we list here does matter, because there are some judges who, no matter what, even if they look at it, if the DA is objecting, they're not going to let that person out. And so I think we want to talk about, are there crimes that we do want the backgrounds run? Say, I think burglary 2 was on that list. Now, this doesn't mean burglary 2 would always get out, but if we took it off the exclusionary list, that means they can run the background for someone with a burglary 2, and it would go to the DA's office. I think there's a difference. If someone's breaking into someone's home and in their living room, that is very different than a homeless person sleeping in the garage. I've kind of seen burglary 2s on both of those. My opinion is I would want that person screened, because the DA's office is going to object if it's someone in the living room of someone's house. If it's someone who, you know, is in the garage, I want them to be able to look at that person and say, okay, depending on the priors, if this person doesn't have priors, then maybe that's someone who we could get out with conditions. So that's kind of why I wanted this on here, to see, is there anybody who's in CIC should be run. Obviously, I think like murder 2, all of those crimes, we would never need those crimes looked at. Those are going to be objected to anyway. I think the ones I had questions about are burglary 2, I just mentioned. I think burglary 1, since it's of a residence, when someone's home, that's something that we would want to leave on the exclusionary list, but potentially like
assaulting a peace officer, we should just stay on that.
Right. So I think the ones that I would potentially even say, hey, this person should be screened, are probably burglary 2.
I would agree, because those are so across the board. I guess this is burglary 2 of a residence, so it's not burglary 2 of an automobile, burglary of a residence.
Right. Yes.
You know, it does.
So burglary 2, the kind of what I was saying is, so burglary 2 is an unoccupied residence. I've seen cases where they're in the living room, and then I've seen one where it's in the garage sleeping. And so burglary 2, I would ask that not be on there. So it could at least.
What they would say, burglary 2 of an occupied residential dwelling, something like that. Would that make a big difference, you think, or would that be?
So if it's burglary 2, it's just never occupied.
By
That's
definition.
right.
Right.
By definition, it's
And-
burglary 1, right?
Yeah, and so I would think that burglary 2 should be something that we should run their background. Obviously, if they have a bunch of priors, then they're not going to get out. If it's something that they run their priors and don't have many priors, then it would go to the district attorney's office, and they would either object or agree, and then it would still be up to a judge. So I just think burglary 2 is one of those that it should at least have the background screened. That doesn't mean that person's going to get out. The district attorney's still going to look at it, and then the judge is still going to kind of look at the facts. So that would be my opinion, maybe burglary 2, and then on, I think, distribution, sale, or possession with intent to distribute a meth. I know we talked about that one last time. Again, if we took that off the exclusionary list, that just means that court services would run the backgrounds of those. Because in my opinion, it's very different. If someone is a drug dealer, the DA is obviously going to object to that person getting out, so they wouldn't get out. But if someone has very small amounts of residue in packages, I think that person's history should be screened, because if it is someone without priors and it is residue, then I want a judge and a DA to be able to look at that. I don't know if anybody has opinions on that, but those are kind of the 2 on that list that.
I've got a comment on this. I had something come up. I had a list sent to me by somebody at the jail. It's got Brandy's name on it. It's dated July 9th, and it's titled charges. And I don't have a way to print it. Charges that NCIC should not be run on. It doesn't say that it's a mandatory exclusionary crimes list, but what other reason would they be running these things? And this list is very different than this list. So I don't know where this list came from, but I think there may be something happening at the jail that maybe this body has not weighed in on in any way.
Yes, I think there was question, and I think at some point, because again, the old exclusionary list, if it was requested by the DA, the public defender, an attorney, or a judge, then they would go ahead and run the background. And I know the district attorney's office, that may be the list, I'm not positive, that Ms. Behenna at some point said, hey, can we run NCICs on these just to see their backgrounds? Again, that didn't mean any of those people would be agreed upon, but if it was someone who had no priors, then they could at least consider their release. And so I don't think the jail's going by that list right now. I think it's for us to decide right here today to make a recommendation to the commissioners is this is what we do want screened, this is what we don't want screened at all, if that makes sense.
And let me add some clarity here. The list that you're looking at that's on the screen is a mandatory exclusion list. This was signed by the county commissioners in March of 2008. So in addition to this administrative order, under 1105.3C, there are 40 crimes that are listed by statute that are not eligible for pretrial release without a judge's signature, okay? So, I mean, I think what we need to do is decide what we were trying to do, what this list was, the charges that NCICs should not be run, if you can say that.
Yeah.
We were trying to help court services. They were so far behind in running any NCIC charges. We said, look, if it is a murder by any degree, don't run an NCIC.
Yeah.
They're not going to get out, okay? That's what we were trying to do, is help streamline it. This wasn't an administrative order that's not been adopted by anybody. We were just trying to get court services to move forward and give us the NCICs that we really do need. For instance, 1105.3, the list of 41 crimes, and 1105, or the 40 crimes, these people are eligible for release if a judge signs off on them. Well, these are the ones we absolutely need NCICs on, right? Because these are the people that a judge might sign off on, but he might not know a criminal history. So that's what we were trying to do. There were so many people had their hands in the pot, and there was not clarity about what needs to happen. But I would suggest, I mean, Bridget, we can work together and make a proposal. How about that? Many of the crimes that were on the mandatory exclusion list from 2008 were included on this. There were some that were not.
I've got a breakdown of the crimes that are on there.
And I do think, we've talked before, when it says distribution or sell and possession with intent to distribute meth, that should be anything. I mean, right?
Yes, yeah.
Fentanyl should be. I mean, so we shouldn't just say meth. So if you'll let Bridget and I work on a list, and the things that we can't agree to, we'll just put, if that's okay. And Judge, if you want to be involved in it, we can have you. But I'm just thinking, let the lawyers get together, let us put a list together, and then for the ones that need discussion that we can't agree to, then we can talk about it as a group, if that's okay.
Yeah, the big one we had a problem with that is on this list, the historical list from 2008 that's not on that list, was the assault of a police officer.
I agree. And that's down here, I've added
You
that.
added that, okay.
Yeah, but it didn't, I mean, so if we can do that, just let us chat and then we can come back to this. Is that okay?
Yeah,
Table it and come
absolutely.
back.
And I think most of the list is pretty good. I think there are just a couple that we may want backgrounds on. or not
Right, and
want
clarity,
backgrounds
like I
on.
said, number
Yes.
17, it doesn't just need to have meth. So,
Yes.
but I think we can
Okay.
put a list together between the three of us and then present it.
Okay, so we will leave that, we'll leave that as a recurring item for now, and then, we'll get together and make that list and then present it to the board.
So while I've been sitting here, I think I've heard of 3 different lists.
Yes.
How many lists we got out there?
Well,
Those 3?
this one is not an official list of anything.
But you
So
got
we
the
have
list,
2 for sure.
but you got the list that the undersheriff was talking
That-
about. You got the list that we put together back, I think you said
2008.
2008. And then you got the 3rd list that's statutory. So you've got
Right.
3 lists out there. right?
Well, this list,
No, I understand that,
but this is the one the undersheriff is talking
Yeah,
about.
oh, that's the one, okay, I'm
This
with
is the
you.
one he's talking about.
I'm with you.
This is an unofficial, I was just trying to get court services to start giving us some information so that we could make informed decisions on pretrial release. So
Okay.
I've thrown this in the mix. It's not official. Maybe I've confused more things than I've helped. I was just trying to get something moving.
And it's just that the statute has so many crimes on it,
Yeah.
like unauthorized use of a motor vehicle is on there. And I think it also says if anybody has 2 or more priors, so based on that list, if someone had 2 priors from 1990, as it stands, we wouldn't even screen their background, which I think if you have 2 priors from 1990, but you've been out of trouble for 30 years, that is potentially someone we could get out on pretrial release, so we would want the NCIC. And so that's why the statute differs from that, because we want that person screened. A judge still has to sign off on it, so it's,
Because, I mean, we can't deviate from this from the statutory, can we? I mean,
We can, because a judge on these 40
Oh, I see.
crimes,
so,
a judge can sign off on it.
okay, so the judge can.
That's
okay,
why criminal histories are critical,
I got you.
because you can't make an informed decision about whether you're gonna let somebody get out on pretrial release without
Okay.
that NCIC.
yes.
Okay.
And so this exclusionary list is just who do we want screened? It doesn't mean that no, they won't get out, or yes, they would. A judge and DA still are gonna review it. It just means who do we not want criminal backgrounds pulled on?
We don't need to waste our time.
Yeah, we don't need to waste our
Yeah.
time on a murder 1, a murder 2, assault on a peace officer, robbery, in my opinion. There are only a couple of those that we would want to see the backgrounds on to say, hey, maybe, depending on if they don't have any history, then maybe this bird 2 or maybe this methamphetamine is okay on this person with conditions, if that makes sense.
Okay, so
Okay.
do we have to make a motion?
We
Table this and then
Yeah.
put
leave it
a,
on a recurring item for next time. And then on the next 2 items, on number 5 and 6, it says discussion and possible action regarding the Court Services Bureau monthly statistics report. And then judicial statistics report, that's on 5 and 6. I left those on there because they were on there last time. Do we want to strike those? And then at the next time, we'll figure out what information we want from Jamie and put those on.
I would strike 5 and 6.
Second.
Okay.
And 7 too, really, because 7's a duplicate of 2. I guess we both maybe called it at the same time, put that on there.
Yeah, yours was on there last time,
It
so
was
since we had.
deferred from last time, so it had
So
to.
it was still,
Strike 7.
So it's,
okay, so,
I'm sorry, do you second that change?
okay, so we're striking 5, 6, and 7, all in favor,
Aye.
all opposed?
That's the most progress I've seen us make in years.
And then, do we have any citizen participation?
you already had it.
Any board comments? And any new business?
move to adjourn.
Second.
All in favor,
Aye.
all opposed?
Here's the question, how do we get to the next
At the
agenda?
very top,
It's at
half the next one.
Well, that would be that one.
And so the next meeting is the mental health board regular meeting agenda. Call that meeting to order. Notice and the meeting was properly posted on June 24th. We'll do another roll call.
Brian Vaughn.
Rick Warren. Judge Stoner.
Jim Anderson for Tommy John.
Butch Freeman.
Vicky Benham.
And Bridget Biffle. Discussion and possible action regarding the minutes of May 9, 2024.
Accept the minutes.
Second.
Okay, all in favor?
Aye.
All opposed? Okay, we have a discussion and possible action regarding an update on the mental health court monthly statistics report.
Excuse me. So as of May, we've put in 35 people. Since we started the year, we have 103 new participants in our court program. So we're growing quickly. I think we do about anywhere from 2 to 6 new pleas a week. So we're getting higher and higher. We have 371 participants who are in our court program, but only 253 are active. And 40 of those participants are in county jail or other counties, like 40 are in Oklahoma County, and then 32, back up. 32 are in Oklahoma County jail. Now that's like picked up on a new charge. They're pending DOC pickup to go to IRF. Not pending inpatient treatment, I can tell you that, but working on a release plan because we don't really want to release our individuals out into, the community with no stable housing. So we're getting treatment in there and diversion hub in there to help us get those people housed quickly. So we're trying to get them out as soon as we possibly can. We have 6 other participants in other county jails. They picked up a new case, or they're picked up on a warrant from that county. We have 18 participants in inpatient treatment. We have 6 in DOC, so 6 months IRF. 4 of those are male, 2 of those are female. We have, as of February 2008, we have 112 participants AWOL. That is, since 2021, that's 4. As of 2022, there's 15. 2023, there's 14. And unfortunately, 2024, there's 44 currently AWOL. Yes.
And how many graduates?
Oh, I'm sorry, I don't have that right off the bat. I can get that the next meeting for you, absolutely. Lost my train of thought. We had a team meeting last Friday, and we're really trying to have the jail release our new individuals, our new pleas out before 10, 11, 12, 1, so we can get them to their treatment provider, to my office to get signed up for drug testing, my intake, get them to DOC, get the DOC intake completed, getting them established with the diversion hub, and then getting them to their sober living facility. This week was our first week to try that, and I think we've only been successful 1 day. But we're still trying, because we find that we get them to me and diversion hub and DOC and into sober living, but unfortunately they're not making it to our outpatient services because they don't have any means of transportation, or they just don't know where to go or how to get there. So we're trying to hopefully fix that to where they can get everything done in 1 day.
Okay.
Does anybody have any questions about that?
You mentioned that you've been having trouble and you don't end up with a full day, anywhere near a full day to get all these many things done. Have you worked with, and are you currently working with the jail staff to try to get them earlier?
Yes, sir.
Okay.
We have made, I know Judge Burton has been in contact with the jail. I know that we have Officer Bradley, I think he's Captain Bradley, or maybe he might not be Captain, I'm sorry, but he has reached out to county as well to see if we can possibly get that done sooner. I think they are being pulled, from my understanding, they're being pulled. It's just the releasing process that's taking forever. And we have recovery navigators through the diversion hub who are there waiting to pick them up, to transport them to everywhere, but unfortunately, they're waiting hours.
Help me with the terminology here. When you say they're being pulled, does that mean they're physically taken out of their cell?
Yes.
And brought downstairs, and then they start the waiting process that could last for a significant amount of time from down there.
So they're probably like us, they have one person processing people going out. Because that's not typically a place where you have problems. Typically your people that are stacked up coming in are the ones you want to get out of receiving because they're either drunk or high or pissed or whatever. So
you're saying those people that are getting out are very cooperative?
typically.
It's
Every
just
once in
been-
a while you gotta fight somebody to get them out of jail, which is a really weird deal.
That is a weird
But it
deal.
absolutely happens. It's the weirdest
In the
thing.
13 years I've been here, this has always been an
It's
issue.
always been a conflict.
Yeah.
It's always been a problem.
I know we don't have people take on health inspection,
No.
the people are around, I don't
Yeah.
know, I don't know whether building new, we can't take care of what we've got right now, but, one thing that we started doing that tends to help is if you'll email Lieutenant Logan the day before, gotta email him the day before, this person needs to be out by 8 o'clock, he's generally pretty good about getting them down and getting them out by 8 o'clock, but you
So we
gotta,
did that this week,
yeah,
and it worked 1 day.
No,
but I think he was also, might have been on vacation last week, so I think
okay.
hopefully, things will get better.
He's
but-
at a training at Chick-fil-A,
Yeah.
and he
Okay.
normally, anytime I message him,
Perfect.
within an hour or two, he has
Yeah.
someone picking them up, so.
And he's recently been promoted. He's no longer the guy in receiving. I think he's a captain or a major now. That's running it.
Yes.
Well,
a lot
I
there.
would put on there, releases first at 8 o'clock, the be pretty well, and it maybe happens 20% of the
I
time,
think Judge put 6 a.m. and it's still,
to get them out by 8, yeah.
and it's not 8.
No, I know.
It's way later than that.
Yeah.
But we're doing the best that we can, but obviously, our recovering navigators at Diversion Hub, I mean, they're there, they're waiting, and they're trying to get them to everywhere they need to be. We just would like for them to have everything set up, established, so they don't have to stress about making it to treatment, 2 days, day later.
Particularly for this population.
Exactly.
Would it be possible for you to send the stats that you told us about? Could you email that? Okay, thank you. I'm just
I think that's
worried
also the
about
paper, but.
Yeah.
Is it here?
Yes.
Okay, that's all I need.
And I have to get with Department of Mental Health so they can revamp my form.
Motion to accept report.
Second.
All in favor?
Aye.
All opposed? Okay, and then also, the last 3 pages, I don't know if everyone saw the last 3 pages, was the mental health court budget. It was of that other packet that was in there.
Are you talking about these 2 pages, the last 2?
Yes, for the last 3, one says mental health court fund,
Right,
well,
right.
84, yes, and then 2
Okay,
pages.
those.
And then number 4 was discussion and possible action on transferring the operation and management of duties from court services. I think that was put on by Judge Stoner. That was the one we struck from the last time. It was just on here as a recurring item from that last one. Do we want to strike this from?
Yes.
All of them. Second.
Second.
Okay, all in favor?
Aye.
All opposed? Okay, and then the next thing I have on the list, discussion and possible action regarding merging mental health court, veterans court, and drug court to have just one treatment court advisory board. This is kind of something we talked about because I know it's kind of repetitive what we do on these 3 boards. And Ms. Behenna and I had discussed maybe just potentially, since it's the same members and the same boards, just kind of combining it all into one. Also, when we have this savings from state question 781, there was some question about how that money gets through. I know Tulsa did it they have a treatment court board, and so that board kind of regulates and monitors all the 781 funding to make sure it goes to the right place. And so we could potentially set ours up like that, and then so it would be all the boards combined.
Make a motion to combine.
What name do you want to give it? Because I need to know.
We treatment court advisory board, or treatment courts,
Courts, yeah,
Yes.
advisory
Courts.
board.
Advisory board. Okay. Can you repeat your motion for me, please?
Motion to combine all into treatment courts advisory.
And that would be the mental health, drug court, and veterans treatment.
Veterans court, yes.
Second.
All in favor?
Aye.
All opposed? Okay, that motion will pass. And then do we have any citizen participation? Board comments? Any new business?
Move to adjourn.
Second.
All in favor?
Aye.
Opposed? And then we have what's the drug court next? Okay, the drug court, regular meeting agenda. Call this meeting to order. Notice in the meeting was properly posted on July 24th. We'll do roll call.
Brian Mon.
Rick Warren.
Judge Stoner.
Jim Anderson for Sheriff Tom Brown.
Butch Freeman.
Vicky Behenna.
And Bridget Whipple, discussing impossible action regarding the minutes of May 9th, 2024.
Motion to accept the minutes.
Second.
Okay, all in favor?
Aye.
Aye.
All opposed? And then we have discussion and possible action regarding the drug and DUI court statistical report. I know David, they had an All Rise conference, or all the members of All Rise here, so I think he was at that conference.
I need to get over there soon too, so.
And so I think we can just leave that on for the next one and have that update.
And just add a follow-up. Okay.
Yes. And then on number 4 was the same recurring from Judge Stoner, the transfer of the operation and management. We'll move to strike that.
Motion to strike.
4 and 5.
Say,
4 and 5.
Right.
Okay, and so all in favor?
Motion to strike 4 and 5, and Judge Stoner second.
Thank you.
And then all in favor?
Aye.
All opposed? And then any citizen participation, board comments, new business?
Move to adjourn.
Okay, second, all in favor?
Aye.
All opposed? Then the Veterans Treatment Court Advisory Board, call this meeting to order. Notice of the meeting was properly posted on July 24th. Roll call.
Brian Mullen, Rick Warren.
Judge Stoner.
Jim Anderson, Petroni Johnson.
Butch Freeman.
Vicky Banner.
Bridget Bickle, discussion and possible action regarding the minutes of May 9th.
Motion to accept the minutes.
Second that, all in favor?
Aye.
All opposed? And then discussion regarding the program status report. I believe they are probably also in that All Rise conference.
Oh,
Oh,
she's
here we
here.
go. We've got Cindy here.
I have for Kyle today.
Wonderful.
Since the last report, we have added 3 veterans for a total of 45 active right now. We have graduated 3. 3 were unsuccessful. We have 3 AWOL, 1 Tony Bell, 1 in federal custody, 1 in a 6-month DOC section, and 42 are actively drug tested. 47 are actively drug testing. And that's it.
How are things going there?
They're great. Everyone's really smooth.
I know Judge Dishman's been activated, right? But he comes back to the docket.
Yes, we're having 2 where it's sanctions only. We kind of communicate with him on outside because for our trouble best participants. But other than that, we have 1 more of those, and I think he'll be back up next week, I believe.
Oh, is that okay?
Motion to accept status report.
I got a question on status report before we do that. 56 number graduated veterans, running total 3 since last report. Who determines, how are they determined to be ready to be graduated? Who does that? Do you do that?
The staff does.
Okay, so
They completed all the phases.
all right, so they do have, like, you have some numbers that you're tracking, i.e. the phases. So it's not all just a subjective
Oh,
evaluation.
correct.
They show up every downstairs, jury assembly room, have big meetings and
Okay.
answer questions and talk about what they're doing, what they're accomplishing.
So it usually takes 18 to 24 months for them to go through phases. You gotta go through phase 1 requirements, phase 2 requirements, phase 3 requirements, phase 4 requirements, aftercare requirements, certain number of drug tests.
Got it.
It's really objective.
That
It's
It's interesting to go down and watch it. They're actually
Yeah.
pretty strict on it.
I try to avoid the jury rooms as much as I can.
Especially going
Brings
back
back
to your
nightmares.
veterans. Might find out you need to go to those meetings. I stay away from myself.
Who are we?
Okay, we have the motion. Who seconded that?
Nobody yet.
Second.
Brian did.
Okay, all in favor?
Aye.
All opposed? Okay. And then, was that 2 or 3?
That was 2.
Okay. Okay, discussion and possible action regarding the Veterans Street Court, budget report.
He
Table
said
that.
this is the BJA grant. This is the final budget is what he's saying. You just let me know when you're ready for me to scroll down.
I think we should, my motion be to table this till we have somebody from the, really, till Kyle's here to walk us through what's going
Have a
on.
motion, Judge.
Yeah, I'd move that we table this
Second
item
that.
until we.
Okay, all in favor?
Aye.
All opposed? Okay, and then,
Move to
almost,
strike 4 and 5.
okay, I'll second that.
Second. So,
And then all in favor?
Aye.
All opposed? Any citizen participation, board comments, new business?
Move to adjourn.
second.
All in favor?
Aye.
All opposed?
I did not realize that the veterans program was that long. Did you say 18?